Good afternoon. Welcome to today's webinar, Lucia versus SEC. What does this decision mean for regulated businesses? My name is Meredith Boyle, and I'll be moderating the discussion today. I am a member of Venable's Commercial Litigation Group. I handle civil litigation matters and investigations with focusing on financial services clients. Before we get started today, a note about CLE. CLE will be offered for today's webinar, so stay tuned until the very end for the code, which will be given in our Q&A chat feature during our program. The CLE certificate information about the CLE certificate will automatically be sent to attendees after today's session. Also, our webinar today will be recorded and downloadable, and the slides will be available later this week along with the YouTube of this presentation. If you have any questions during the webinar, you can submit them through the Q&A widget located at the bottom of your screen. We will try to answer these during the webinar, but if a fuller answer is needed or we run out of time, it will be answered later via email. Please know we do capture all questions. Before we get started with the subject matter of our presentation today, I'd like to introduce my colleagues who will be participating in the discussion. First, we have John Cooney, who is a member of Venable's regulatory group who has extensive litigation experience. He is the chair-elect of the American Bar Association's Administrative Law and Regulatory Practice section and has 35 years of experience in regulatory policymaking and regulatory litigation. He has deep experience representing financial services and environmental clients in regulatory proceedings. We're also joined by Allison Baker, who is a member of Venable's litigation and financial services practices. She has spent nearly 2 decades litigating financial services investigations and enforcement matters, as well as more traditional litigation matters, both for the government and as defense counsel for individual and commercial clients. One of the initial team of attorneys at the CFPB, Allison was an enforcement attorney and helped develop policies on enforcement and investigations. She has represented clients in CFPB administrative enforcement proceedings, as well as district court proceedings. We're also joined by George Kostolampros, who is a member of Venable's White Collar Litigation Group, who has substantial SEC enforcement experience. George brings nearly 2 decades of experience in investigations and litigation, including as senior counsel in the SEC's Division of Enforcement and in private practice representing clients in investigations before the SEC, Department of Justice, and other government agencies. He has represented clients in SEC administrative enforcement proceedings, including defense of a matter that has proceeded through the administrative process and is now pending decision before the D.C. Circuit on appeal. Finally, we are joined by Peter Frechette, who is a member of Venable's regulatory group with a focus on financial services work. Peter counsels clients in examinations and enforcement matters and has appeared before the CFPB in an administrative proceeding and regularly advises clients with matters before agencies including the FTC, FDIC, and OCC. So let's begin. Before we dive into the nuances of the Lucia decision and the constitutional implications surrounding the appointments clause, I thought it would be helpful if we talked a bit about administrative proceedings generally and who administrative law judges are and what their experience may be in any given matter. So Allison, would you mind giving us an overview, just generally speaking, of administrative proceedings before an agency?
Sure. I can speak about my own experience appearing in the CFPB, the Consumer Financial Protection Bureau's administrative adjudicatory process. We were before an administrative law judge who at the time was on loan to the Bureau from the Coast Guard, I believe. I think the CFPB has subsequent to that retained its own administrative law judges, and actually when the agency was first stood up, it had an agreement with the Securities and Exchange Commission that it would share an ALJ, an administrative law judge from that agency. The administrative law judges are hired by the agency, and they're hired for the express purpose of overseeing adjudicative proceedings before the CFPB or before the SEC, and my colleague George can talk more about that. Among other things, those ALJs are responsible for conducting and presiding over trials or hearings, if you will. They take evidence. They decide on the credibility of witnesses. They make evidentiary rulings. They ultimately are fact finders and also render conclusions of law and are charged with making recommendations to impose penalties and or other kinds of equitable relief, including injunctions, restitution, disgorgement, in the case of the CFPB. the Bureau can either choose to bring an action before the administrative law judge, or it can go into district court on all of the same legal arguments. And so that's one of the issues we'll talk a little bit more about today. And I know George has also appeared before the SEC's administrative law proceeding as well. So if you want to...
I'll add some color around the SEC's administrative law judges. There are 5 in total. There's one chair, or chief judge, I should say, who's been there for probably a couple of decades, if not more. The chief judge is the one that hired the other 4 judges until the appointments clause issue came up, and now, about a year ago or so, maybe a little bit less, the SEC itself appointed its ALJs in a turn of its prior opinion that there was an appointment clause violation. But a little background on the judges. The judges, other than the chief judge, who's been there for a number of years, as I mentioned, their backgrounds are divergent. I was before a chief judge, or a judge, an ALJ before the SEC. That judge's background was as a prior Social Security administrative law judge, and before that an IP lawyer. So, and we'll get into this possibly a little bit later on, but there is this, I would say, a misunderstanding that these judges have particular experience in that particular agency and that particular set of laws, and in my case, securities laws, and that's really not the case. Obviously, for the chief judge, who's been there for a number of years, probably built up some understanding and probably an explicit one, an expertise potentially about the securities laws. But for the other judges, it's not the same. So just a little color behind that.
And George and Allison, what in your experience is there a risk when you have non-subject matter experts in these agency proceedings? Given that the review process is somewhat different than we would be accustomed to in federal court or even in state court, have you perceived any problems in having a non-subject matter expert render a decision? And I know we're going to be talking about whether it's a final decision or not, and then have that decision potentially reviewed by another level within the agency. Are those individuals who are charged with reviewing the ALJ's work, are they uniformly attorneys? What is the composition of the commission, that's reviewing those decisions?
Well, the commission, some of whom are attorneys, some of whom are not. Some of them may be, scholars, maybe professionals at the SEC, the commissioners themselves. Getting back to the ALJs, I think it's a real problem at the end of the day when you have non-subject matter experts being basically judging the conduct of, in the securities forum, the SEC's administrative forum, the conduct of financial professionals in the securities market. They may not understand how the securities markets work, and unfortunately, there is not the opportunity to have a wholesale sort of discovery and present evidence as you would before a jury. So you may say, well, look, if you took a case to the jury or to an Article III judge, it's not necessarily that those individuals and that judge would have expertise as well. But the difference is that you get to present evidence to show exactly, to basically educate the judge, educate the jury, and you're limited in the SEC administrative forum. I think that's a handicap, and it clearly was a handicap in our case, and I think in other cases, and why defendants complain about the forum itself.
So similarly, in the CFPB forum, there's a couple of distinctions between that forum and, say, an Article III district court proceeding. First of all, it's a much more truncated discovery process, and a process for taking evidence, if you will, is much more truncated. It's much shorter. It's much more contracted. Number one. Number two, the rules of evidence, the federal rules of evidence upon which, we litigators kind of rely when we proceed to court, are not per se followed in the administrative law proceeding. And so some of the standard ways that you might pressure test credibility of a witness or a statement that's entered for the truth of the matter, not a court statement, so-called hearsay, those rules don't necessarily apply consistently in the administrative forum. I'd say the other issue that is curious, and it's one that Meredith touched on, is at least with respect to the CFPB and obviously with respect to the SEC as well. The Bureau has a director, and there's nothing in the rules of the Bureau or the enabling act of the Bureau, the Consumer Financial Protection Act, that requires that the Bureau director be an attorney. In the case of Acting Director Mulvaney, he is an attorney, and his predecessor, Director Richard Cordray, also is an attorney. But it could be that neither of them was an attorney. And so to your point, Meredith, when you're reviewing a filing and you're reviewing papers and you're reviewing fact findings and legal conclusions, to have that review happen by a group of people or an individual who aren't necessarily attorneys obviously changes the situation as well. And you could make arguments in either direction, maybe they're good or bad, depending on your perspective.
Okay, so with these observations underlying or animating the discussion around Lucia, Peter, could you please give us an overview of the Lucia case and the Appointments Clause issue that is at the center of it?
Sure. So specifically to Lucia, obviously, as discussed, it was a case that arose in the administrative forum of the Securities and Exchange Commission. The SEC's ALJ heard the case and assessed a violation, civil penalty for alleged securities law violations. That was heard and upheld by the SEC, and then as it came out of the administrative process, the D.C. Circuit heard the case, upheld the decision, and also held that the ALJ, who initially heard the case, was not an officer subject to the Appointments Clause, consistent with D.C. Circuit precedent, namely the Landry case. So Lucia was one of the first fully litigated adjudications to kind of come out of the administrative forum, the agency process, and make its way to sort of federal court proper. There's been a variety of cases that have tried to use the ALJ Appointments Clause issue to exit, before going to a final agency decision, that administrative process. You see that coming up in the Second Circuit, the 11th Circuit, as well as the Seventh Circuit, where parties have attempted to sort of get out of the administrative forum early by arguing the Appointments Clause issue, and that hasn't really made it all the way because there are standing issues, and you do have to proceed through the administrative process to a final decision before you do get out and get that review by a federal court. And the courts are very hesitant to step into the agency's process and to basically, yank the case away from the agency until they do get that final decision. So it's a very difficult argument to make. But Lucia did go through, did get a final agency action, and so then was able to bring these appointment clause claims up. And the case really arose, as all of these cases have, as Dodd-Frank for the SEC expanded the powers and the effect of the SEC's administrative forum, and created, at the same time, the forum for the CFPB, which is, built almost in parallel. And so the expanded authorities included allowing the SEC to seek and obtain the same remedies in their administrative forum that it could if it proceeded in enforcement action in federal court. So really, took many steps to really make a one-to-one, sort of correlation for the SEC in terms of bringing a case in federal court or in its administrative forum. Obviously, as we just heard, there are in the administrative forum kind of reduced procedural and evidentiary mechanisms and protections. That tends to be an expedited process, and there are other issues there. But in terms of what the agencies could seek, that became closer to what they could do in federal court. And so, you saw an uptick in cases brought in administrative forum and parties attempting to get out of those and kind of raising these Appointments Clause issues.
Is there once the cases proceeded through the administrative forum before the agency and a final decision is reached, Is the final decision of an agency that's gone through the administrative process subject to the same level and scrutiny and review as, in the federal court system as, say, an Article III judge's decisions would be?
Well, so yeah, you don't have the same type of de novo review you might have with an appellate court reviewing a trial court on some issues. It's much more of an APA-style review of the agency and whether or not its decision and its decision-making process was arbitrary or capricious, or there were other issues on the record, and you are bound by that administrative record that's essentially built and curated by the administrative law judge, primarily the hearing officer. So it's a different footing coming out of that agency process than if you had a case before a trial judge and then appealed that up to the circuit court.
Mm-hmm. Interesting.
So just to kind of wrap up the world leading up to this Lucia case, many different circuits are hearing this issue, and it's kind of percolating up. It also arose in the FTC's context. In LabMD, the party there raised this issue of the ALJ. I think in that context, it was a removal powers rather than an appointments clause issue. They got shut down by the commission, although the commission did ratify the appointment of its ALJs after that, about 2 years, a little bit over 2 years before the SEC finally did. And so that's kind of an interesting way. The SEC's sort of not failure to, but decision not to ratify until about a year ago, its ALJs kind of, I think, pushed this case along a little bit because it remains such an open issue the way it hasn't really in the FCC's context. Just a brief timeline of some of the more recent happenings in the Lucia case. Obviously, back in August of 2016 was when the three-judge panel of the D.C. Circuit held that the ALJs were not officers subject to the appointments clause. Later, about a little under a year later, the D.C. Circuit denied a petition for review, which led to a petition for writ of certiorari to the Supreme Court, which was granted. And then, interestingly, right before the petition was granted, a couple of months, the SEC did go ahead and ratify the appointments of its ALJs and asked them to, upon ratification, go back and reconsider these cases moving forward as an attempt, I think, to kind of try to cure some of these issues and maybe prevent the case from getting up to the Supreme Court. Ultimately did not, and just a few weeks ago we had oral argument in front of the Supreme Court on this issue. So the issue. Before we get to the issue, what caused this to kind of bubble up to the Supreme Court is you did see develop a true circuit split. You had the D.C. Circuit, which for many years, beginning with Landry, the FDIC, and it followed up in the Lucia case, has held that the ALJs are not officers of the United States. They're mere employees, and has kind of used as its linchpin the idea that the ALJs do not have final decision-making authority. Their decisions do need to get reviewed by the Commission in the SEC's case, or obviously in the CPB's case, the director. The 10th Circuit in Vandermeer, the SEC, took the opposite approach and said there are a variety of different authorities that the ALJs exercise, and when you add them all up, they do rise to the level of an officer of the United States, which is the exercise of significant authority. So you see that in the question before the Supreme Court. Have specifically SEC ALJs exercise significant authority of an officer of the United States during the adjudication? Does that implicate Article 2 of the Constitution, the Appointments Clause issue, which would require these ALJs, if officers, to be appointed by heads of department is going to be the primarily applicable one, which would be the Commission. And The courts have, D.C. Circuit and 10th Circuit have differed on this. The 10th Circuit looked at, this array of authorities, including, making credibility findings at the hearing, essentially at trial, which are then relied on and used by the commission, given considerable weight, was the term used when the commission's reviewing the decision. They shape the administrative record, they take testimony, and handle evidentiary issues. Like I said, they're curating that administrative record, which is the basis for all subsequent analysis and appeal of the case. Ruling on discovery, admissibility of evidence, like I said, and dispositive motions, entering default judgments, and issuing initial decisions that are publicly declaring respondents liable and imposing sanctions. So they're creating a record, they're creating a public perception of parties responding to these cases. They're making decisions that will affect, if not control, the agency parties reviewing, and ultimately the federal courts reviewing these cases. 10th Circuit looked at that and said, we think there's enough here to call these ALJs officers. The D.C. Circuit has really focused on the final decision-making authority and really looked at the fact that, in their view, the ALJs issue only recommended decisions, and they're not necessarily binding until the commission, or in the case of the CD, the director approves it and upholds it, and the director and the commission have authority to find additional evidence, take additional testimony, push the case in a different direction. So that's really how the circuit split has developed, and how the question before the Supreme Court has come up. And just quickly, before I turn it over to John to kind of discuss in more detail, some of these issues that the justices are now facing with what this case means, what the ALJ's status as either an employee or an officer means, and what that might mean for the system as a whole. Just kind of looking at the possible consequences of the court's decision for the parties raising these issues. They're raising them because they want some sort of relief, and people are interested because there might be relief in these cases and others available. So just to run through really quickly, in finalized cases, there's likely no additional relief available, meaning if you've finalized the case before the SEC and it's gone all the way through on appeal and it's completely over, you're likely going to be kind of treated as res judicata, and you're not going to be able to come back and say, hey, wait, the ALJ who heard my case wasn't appointed, so we should reopen this issue. That's a very difficult road to hoe.
Do you know if those appointments clause issues, were those regularly raised? I know you talked about them a little bit, about different cases that never made it all the way through the system, but was that habitually raised by? No,
not until recent years. And again, like I mentioned with LabMD in the SEC context, likely raised because they saw so many of the recent cases in the SEC context raising it. But it really wasn't until Dodd-Frank expanded the authority and the SEC became a little bit more aggressive in bringing these administrative actions that you saw people kind of expanding the box, as it were, to find arguments against it, to essentially get out of the administrative forum or push back a little bit.
If I can add, it's an interesting way this issue percolated up. It was defendants or respondents raised the separation of powers issue, which is, we'll get into the PCOB case, teed that up, and the first issue to get to the removal and separation of powers issues is whether the employer, the ALJ, is an inferior officer. And through that litigation, it became clear that no one knew how these ALJs at the SEC were hired. Not even the SEC. So, and then that became, well, there's an appointment clause issue here.
And you saw a bit of a snowball effect as parties raised the issue, sort of created a model for raising it, and then others were able to do the same. Just to wrap up quickly and turn over to John, with pending cases, I've listed some of the issues that might come up. Again, in the appointments clause context, waiver issues. If you've raised the issue previously or haven't, are you able to now raise it? after the Supreme Court decision gives you guidance on whether or not that's worth doing. Harmless error doctrine. This has come up with sort of the idea of what should happen to your case. Is it something that mandates the dismissal of your case outright, or is this really something that can be fixed after the fact and really hasn't created any huge detriment? This is an area that's left open by the Supreme Court on Appointments Clause issues. De facto officer doctrine, could properly appointed officials sort of be ratified retroactively, similar to the ratification issue with SEC and FTC have attempted to do, is kind of say, well, we'll approve the appointments of these ALJs and sort of try to fix the issue going forward. And then, just sort of generally what the appropriate remedy is. Is it a dismissal outright with prejudice? The agency can't go back and retry the case. Is it a remand to the agency to basically say SEC or CFPB fix this issue, have the properly appointed ALJ relook at the record or retry this case and send it back through the process? So all of these considerations will kind of waterfall out of the Supreme Court's decision and affect how parties decide to move forward with their individual cases. So with that, I will turn it over to John, who's going to take us through some of the challenges and issues before the Supreme Court justices.
Thank you, Peter. The decision in Lucia will play a major role in determining the future of an entire aspect of our current administrative state. It will decide who has the constitutional power, to appoint the ALJs who conduct formal adjudications to determine if a person has violated federal law or is entitled to receive federal benefits. There are two options. The president or an agency head appointed by the president, which means that ALJs are going to be selected through a political process and will be political appointees. Or second, the current system, a non-political merit civil service selection process in which the resulting ALJs are not political officials, they're just senior civil servants. Lucia presents a frontal challenge to the entire process that Congress adopted in 1946 to establish a merit-based civil service process to select the ALJs and to select nonpartisan, unbiased people who would preside over agency adjudications. The Supreme Court understands what it's being asked to do here, that its decision will affect the power of Congress to determine how ALJs are selected in many other agencies besides the SEC. These other agencies include some of the most important regulatory agencies in government and are designed by Congress to be independent of the president for that very reason. They include the Comptroller of the Currency, the FDIC, the Federal Trade Commission, and the Consumer Financial Protection Bureau. All of these will be wrapped up in the scope of the argument that is made and the scope of the decision that is made. And the Supreme Court very well understands the broad scope of the decision they're being asked to make. The oral argument showed that the justices are wrestling with the long-term consequences of their decision for the entire process of agency adjudication. And so this broad scope makes it very difficult to predict the outcome of this decision in advance. But Lucia is a complex case for a second reason. In this case, the court is being asked to address the convergence of developments over the last 30 years under three separate constitutional doctrines that affect adjudications. The first is the one I've just described, the Appointments Clause. Must ALJs who conduct adjudications be appointed by the president or the political head of an agency, or can they be civil servants? The second, and the most complex factor in the case, is the removal clause. That is, once an ALJ is in the job, how can that person be removed? And would Congress unconstitutionally interfere with the president's executive authority if Congress gave the ALJs for-cause tenure protection? That is, they could only be discharged from their post if they had committed a fraud or some other kind of heinous act or completely failed to carry out their duties. This is going to be a real problem because of a decision called the PCAOB case decided by the Supreme Court, I think in 2011, which said that generally speaking, it's a violation of the Constitution if the president is two levels of tenure removed from being able to discharge somebody. That is, if the head of the agency is not subject to removal by the president, as is true for most of the important regulatory agencies. And if in that agency is another person who has tenure protection from being fired even by the head of that agency, as most of the ALJs in the federal government are. So without intending to get itself into this box, the Supreme Court is now in a nightmare position that if they were to find that that the ALJs involved in these cases are not inferior offices who have to be appointed on political grounds, they'd run head-on into the tenure protection. There'd be two levels of tenure protections for the ALJs and the major independent agencies, and they might be unconstitutional on a separate ground, which the Department of Justice asked the Supreme Court to consider in this case, but it's pretty clear that that would just overwhelm the system in the same court. They're likely to stick just to the Appointments Clause case, but the justices understand full well that there is a shadow removal case that's just sitting offshore somewhere and that's going to be brought to them very quickly. Plus, as Peter mentioned, there are all kinds of due process challenges here about what the right remedy is if you find that the current ALJs are unconstitutional. Now, these appointments and removal questions directly affect the extent of the president's power to staff and to manage the executive branch, to run it, to give directions that are followed. These questions have been considered by courts for many years, but they really became recurrent front-burner issues only in the mid-1980s, when the Reagan administration became very interested in two major cases that invaded the appointment and the removal. The major appointment case is coming back into public view these days for a different reason. It's Morrison v. Olson, decided in 1988, and it considered the constitutionality of the appointment of independent counsels, whether they were inferior offices and had to be appointed by the Attorney General, or whether they could be independent career-level people, non-inferior officers, and could be appointed through different mechanisms. And the other case, the removal case, was Bowser v. Sinar, which declared the Graham-Rudman sequestration mechanism in 1986 to be unconstitutional because Congress gave the power to run the sequestration to the Comptroller General, an official who is part of the legislative branch and subject to removal by Congress. So ever since that decision came along, the successive presidents have been very interested in the removal power and have taken aggressive steps to try to give them a greater say into who is appointed and the situations under which that person can be removed. And finally, there's a third complicating factor here. With the change in administrations, the SEC changed positions and no longer is defending the position it had below. In the Court of Appeals, where it took the position that the ALJ statute was constitutional, there was nothing wrong with the appointment of the ALJs. But the current SEC abandoned that position. The Department of Justice appeared on behalf of the administration and made the case that the ALJ appointment provision of the SEC statute is unconstitutional. So there was the party with the most at stake, the SEC, suddenly was neutral. You had the person who'd been hauled up before the SEC on discipline saying it's unconstitutional. You had the Justice Department saying that the statute was unconstitutional, but on different grounds and broader grounds than the defendant had. So there was nobody to defend the decision below. And so the Supreme Court had to appoint an amicus curiae, a very talented 40-year-old lawyer, a younger lawyer in the Supreme Court parlance, to defend the constitutionality of the statute. And that lawyer worked overtime to try to come up with justifications as to why the court could find that the current system actually is constitutional. The argument showed that all the justices are concerned in different ways about the need to try to persuade members of the public and to persuade the individuals whose rights are determined through these agency adjudications that the process is fair and is not biased against them. The conservative justice, especially Chief Justice Roberts, expressed concern that the current method of appointing ALJs through the civil service may not convince defendants that the result of the adjudication is fair, that the defendant wants the president to be politically accountable for this on the theory that only if there's political accountability at the polls will the process be run fairly to prevent biased outcomes. The liberal justices, notably Justices Breyer and Kagan, were concerned that overturning the current merit civil service process of appointment of ALJs and replacing it with a political appointment would undermine the decisional independence of the ALJs and undermine public confidence in the entire adjudicatory process. And this is certainly the position that the ALJs themselves are taking. They've been very active in forums like the American Bar Association and before Congress in trying to make the case that it's vital for the ALJs to be independent. And to do that, they have to remain civil service appointees. Now, with those three reasons why this is complex, let me take you through what the arguments were in the Supreme Court and what the issues are. As I've mentioned, under the Appointments Clause, agency employees fall into three distinct categories, or not so distinct categories. There's the rub. Principal officers, such as the heads of major agencies, who must be appointed by the President and confirmed by the Senate. Those are your department and agency heads. The second category is inferior officers, officers who exercise a substantial amount of power and whom Congress can authorize to be appointed pursuant to the Constitution by the President, the head of an agency, or by the judiciary, the courts themselves, to preserve the independence of the judiciary. And then there's the other category, non-officer employees who exercise less authority and can be appointed through a civil service process. The question before the court in Lucia is whether SEC ALJs, and by extension ALJs and the other agencies, exercise sufficient authority to be deemed an inferior officer, or whether they don't have enough authority and they can be thought of as staff, non-officer employees. The Constitution draws no bright line that separates officers from non-officers, and the court has made these decisions over the years on a case-by-case basis using multi-factor tests, the traditional way that the Supreme Court punts. It adopts a multi-factor test when it doesn't have a red line that it wants to draw. And one of the issues that's turned out to be most important in the prior decisions is whether the person who holds a position can issue a final decision on behalf of the agency and bind the agency and impose obligations and rights and duties on the individual who's hauled before the adjudicatory process. At oral argument, the administration suggested that the court should follow an open-ended standard for deciding when a person is an inferior officer. They said that the court should ask whether the powers vested by Congress essentially give that officer significant discretion on an important matter. And, that's really no standard at all. It could apply in any case, in any way that a majority of the court wanted to apply it. What discretion is significant? When is a matter important? Those are totally open-ended terms and subject to case-by-case adjudication, which is to say whenever you can assemble a majority of 5, you can issue a decision and say, sorry, this role requires appointment pursuant to the constitutional clause. But one of the most interesting things at the oral argument is that the court also asked several questions concerning whether the SEC ALJs in particular could issue final decisions to bind the agency. This comes up because apparently there is a provision for appeal to the commissioners of the SEC, to the 5-person board. But most people who were involved in the ALJ process don't choose to file that appeal. And under those circumstances, the ALJ's decision may become final. And so that was one that the justices focused on quite a bit. The case law background is that the closest precedent for Lucia is the Freitag case, where the court held that special trial judges of the tax court were inferior officers and had to be appointed consistent with the Appointments Clause, there by the chief judge of the tax court. Those judges had powers in conducting adjudications that are much like those of SEC ALJs, and they also could issue decisions that were final in some instances. So there was a direct resonance of the Freitag case with the issues before the court. But the one difference between Freitag and Lucia is that Freitag involved one tiny corner of the government, and that precedent may not be applicable here because Lucia involves a challenge to a central component of the entire adjudicatory process of the federal government. And so that is leading some justices too, to wonder whether Freitag actually is useful under these circumstances. But one thing is for sure, the court is now thinking about application or reapplication of the government governing precedents and the governing principles, and it's unclear how much weight a majority of the court wants to put on the Freitag decision. But as I said, the outcome, what is going to be the outcome? It's particularly difficult to predict because of the scope of the decision, the complexity of the intersecting legal doctrines that are effective, and it's also hard to tell from oral argument whether there are 5 justices in support of classifying the SEC ALJs as inferior officers, or whether there are 5 that are favored classifying them as employees. As always, it seems, Justice Kennedy will play an important role in Lucia's outcome. By luck of the draw, he was on the Supreme Court in 1991 when they decided Freitag, which established the basic ground rules that people are groping for this analysis. And so Justice Kennedy has an advantage over the other justices. He'll have more of a sense as to what the debate was back then and what was considered important. At oral argument, he asked what the effect of converting to a political appointment process would be for the ALJs and the other agencies beyond the SEC. The ones he seemed to be interested in most were the Social Security Administration and the Veterans Administration. There may be several hundred ALJ proceedings in the major adjudicatory regulatory agencies. The Social Security and VA have hundreds of thousands of adjudications every year, and if the court were to issue a decision that required those ALJs to be appointed by agency heads or by Congress, there would be a fundamental shift in the balance of authority within the executive branch that affect many people who are applying for benefits. So Justice Kennedy has unique perspectives on the case. The Justice Kagan seemed to recognize that the straightforward application of Freitag would require the conclusion that ALJs are inferior officers, and for a liberal on the court to make that statement out loud was quite a concession on her part, and is one of the points that leads observers to question whether Freitag is going to be held to be a reliable precedent here, because there is some doubt as to whether it could govern something that's going to have such sweeping impacts. And Justice Breyer expressly was on the fence in this case because of the implications of holding that ALJs are inferior officers, as that holding would be applied in the removal context in light of the PCAOB case. Breyer stated that if the court accepted the administration's proposed approach and held that ALJs were inferior officers, as he put it in his colloquial terms, that holding would mean goodbye to the merit civil service at high levels of the federal government and goodbye to the independence of ALJs. And he seemed to think that the effects were more sweeping than anybody else. So to try to summarize, there's several possible outcomes here. The most basic one is no one knows which side has a majority at this point. So that's to be determined, and may be determined by how the draft majority opinion and the draft dissents get written. And there will be major dissents in this case, however it comes out. Assuming that you know what the outcome might be, you could see that there are several other options that are possible here. One is that the Supreme Court can consider muddling along and apply another multi-factor test that's good for resolving this decision but has no precedent, no value after Lucia is decided. Second, the court could try to draw a red line standard and adopt tests that could be applied in future cases, but there's no reason to think that they'd have a better luck in working out a principle that would have 5 votes than prior Supreme Courts have had, or that the Justice Department has had over the years in trying to articulate them. Third, the court could figure out how to depart from the Freitag case and conclude that there was something particular in the SEC statute that makes the ALJs non-inferior officers in this case, but they were in the Freitag case. That is, try to come out with a traditional way of distinguishing Freitag. And then a fourth way of doing it, which is to try to interpret the relationship between the SEC commissioners and the SEC ALJs in a manner that you could say that the ALJs don't have the authority to bind the SEC in any cases, that there's something about this unusual appeal process before the SEC that means that the SEC commissioners still have the authority to bind the agency, even though they are called upon to exercise that in a small number of cases because the losing defendant chooses to default and not take it to the SEC. But so it is complicated, and it's hard to give you much satisfaction about the test that might emerge from this. I've not seen any academic consensus forming around any of these possible outcomes. It's going to be a crapshoot up until the moment that the decision is released. But the one thing that we can say for certain is how the court determines the role of the SEC ALJs, whether they're inferior officers or staffers. Then in subsequent cases, it will be called upon to apply that decision to determine whether a dual level for cause removal protection given the ALJs and the independent regulatory agencies is unconstitutional under the PCAOB case. And I think really, George, that's where you could probably take us the next steps, trying to explain what's likely to happen,
Sure.
and happen at the SEC in particular.
Sure. Thank you, John. Yes, so the next question is what happens after this case? And, what's before the judges or the court in Lucia is really important. Lucia's appeal is very limited to just the appointment clause issue, and that, I think, was a tactical decision to be made because they wanted to make it as simple for the court as possible so that the court wouldn't have to delve into the removal issue. And I think it's going to take a lot of legal maneuvering to argue, to set forth in a decision how you get past Freitag if the court were to find that SEC ALJs aren't inferior officers based on the Freitag precedent. And just a couple points as to that. There are many issues there about what the SEC ALJ can do and what ALJ similar to the SEC can do. The government consistently argued, well, this is basically going to be repair on the administrative system itself because there are 1,500 ALJs issuing hundreds of thousands of opinions, but not all ALJs are equal. John mentioned the Social Security Administration. That's where the predominant number of ALJs are housed. They're about, I think, 1,300, a little under 1,300, maybe a little bit more ALJs. And that is not even an adversarial forum. So it's a completely different forum itself. So it's the significance of the decision, which is the important standard, I think, in Freitag to remember. It's the significance of the decision and the office itself. For instance, if the ALJ, the SEC ALJ, did not have basically tenure protection and could be fired at will, they probably wouldn't be ultimately so much of a significant issue here because they don't issue. Well, there's an argument about whether they issue a final decision or not, but you have to look at both aspects of this. And I think if you look at the precedent, if the SEC ALJ could actually issue a final decision, they would be a principal officer. How could they make a final decision on the basis of the commission itself and also have tenure protection? It brings us some real thorny issues, I think. But going back to Lucia, the question before the court is the inferior officer issue. Very small, narrow issue, but the justices are grappling with every other issue before it that it can see coming along the way. And what's coming along the way? Ultimately, I see these cases as fundamentally about the appropriateness of the administrative forum. Now, that's the core of it. And unfortunately for defendants and respondents in these cases, it's very difficult to get past the precedent that's been already established by the Supreme Court that it is constitutional to bring these cases in the administrative forum, going back to Alice Roofing, which is a seminal Supreme Court case. The problem here, and that I have with these cases, is that the forum is used much differently back when those cases were decided. The SEC cases that have been brought, historically, the SEC brought follow-on what we call administrative proceeding acts, basically to bar professionals who are investment advisors, broker-dealers, after there was a finding of liability in federal court. You could see why that makes sense. The SEC is a regulatory agency, licenses professionals. They should have a right to decide who should be a professional or not. Now, through bits and pieces along the way, there have been added abilities that the administrative forum could take on, added issues. So along the way, there are more cases that the SEC administrative forum could bring. Finally, we end up with the Dodd-Frank Act, which basically said, look, the administrative forum is just not limited to regulated entities. You could basically bring an insider trading case against an individual who's not a regulated person or entity and bypass federal court. So ultimately, I think the issue is about fairness. And, this basically gets at the heart of sort of the core of the administrative process, I think. The SEC and other agencies frequently act as prosecutor, trial judge, and appellate court when pursuing actions administratively. So what does that mean? The SEC used to describe its administrative law judges as independent adjudicators, akin to federal court judges. That was on their website. It was taken off after these cases were brought because they, number one, referred to those administrative law judges as officers. And then the other issue, which I think is, I think that Gibson Dunn, who did the Mark Perry, who did the Lucia brief, made an interesting point, I think, in his reply brief, is ultimately this is an issue about independence. And, the judges grapple with, well, what do you want? If you ultimately have a removal issue and you strip away one of the tenure protections, doesn't that leave respondents in a worse situation in that they're subject to, there's no independence there. They're subject to basically the whims of the executive or essentially the SEC commissioners, and if they don't find it what the SEC commissioners want them to find, they will be fired. Well, I think most of us would say who practice in this forum is that the independence issue is quite frankly, it's not all that it's made out to be, let's say. In the SEC forum, the SEC wins probably, I think there are the numbers out there before when these cases were originally brought was about 90%. There have been some cases where now the SEC has lost in its own forum, but surprisingly that's only happened since these independence issues have been raised.
George, do you know what the composition of the SEC wins were when the more traditional federal court venues were used with it?
Yes. What happened is it was more in the 60 to 70% range. And what happened, interestingly, is when Dodd-Frank was enacted and the SEC had asked for this expanded authority, it did not take full advantage of that until probably a couple of years after that, after two sets of instances. One is when they were bringing their settled enforcement cases before judges. Judges were taking a hard look at those cases and weren't rubber stamping them. In particularly, Judge Rakoff in the Southern District of New York started doing this, and then when other judges followed Judge Rakoff, this really put a scare into the SEC. And then at the same time, the SEC lost a couple of basically noteworthy cases, in the press, and the SEC started basically saying, "Look, we're going to use this forum. We have it here." And the head of the enforcement division at that time actually said in a speech, "This is what we're going to do, and it's part of our basically pressuring parties that we're investigating to settle." And they later backtracked on that because that just all seems improper of doing that. But that's sort of how we came to the situation of the SEC using its forum much more broadly than before. What it led to was to respondents, counsel, and defendants to take a hard look at the forum itself and how do you challenge it. And unfortunately, it's so difficult to argue, well, you can't be in an administrative forum because of Atlas roofing and other cases, other precedents that say, look, it is constitutional to be in an administrative forum. So they came up with some interesting arguments, I think, one of which was the removal issue. And the removal issue is the difficult issue, I think, at the end of the day to grapple with. Is the appointment issue, I think, is a softball issue at the end of the day. They're an inferior officer. Their authority is significant. They act as a trial judge, as the SEC said on their own website. They formed the record for the commission itself to review. The record could be formed over a number of days with witnesses. The SEC itself gives respondents no more than 45 minutes in an appeal of the case. There's no way that they can actually de novo review the case and sort of rubber stamp it as if it was their own case. So it's really important who's reviewing these cases on the front end. Who's the case before? So that's why these ALJs are inferior officers. But the issue is Free Enterprise Fund v. PCOB. Justice Breyer teed up this issue and his dissent in that opinion, and I believe it was in a footnote basically questioning, what do we do with ALJs? Justice Scalia in Freitag said they're all inferior officers. This is a problem with this free enterprise decision, with the majority's decision. It's going to make those ALJs have 2 levels of tenure protection, and they have basically, there's no authority, the president has no authority over those individuals themselves, and our precedent is that the president can't be 2 levels removed from inferior officers. So what are the arguments here to be made? Again, Lucia hasn't teed up this issue, but other cases have. And those cases are pending. For instance, the case that I'm involved, Timbervest, that case has stayed before the D.C. Circuit, waiting to see what the Supreme Court has done. There are another, I believe, 12 cases pending in various circuit courts that have raised the appointment clause issue, but most of them have also raised this removal power issue, separation of powers. The key question will be, assuming that the Supreme Court finds that SEC ALJs are inferior officers, the next question will be, are ALJs executing executive function? And the reason why is that in the PCOB case, the majority spent quite a bit of time deciding whether the functions executed by the PCAOB had risen to what would typically be executive function. And clearly for the PCOB, which is essentially like almost, I describe it as like a mini agency, right, under the SEC almost, at least that's how it was potentially viewed as, it does a little bit of everything that you would think. It's got a little adjudicative function, it's got regulatory function, it enforces, so that fits the bill. But for an ALJ, the argument will be, and the commission itself, or I should say the Division of Enforcement at the SEC, and then the commission itself, in our case, the Timbervest case, where we raised it before the commission, found that, well, look, at the end of the day, that they're not acting inferior. If the ALJ is an inferior officer, they're not exercising executive power. They're only adjudicating. That's just one little function. They're not really executing the laws. Well, that flies, I think, in the face of, number one, it's an agency. It's within the executive branch. And Justice Scalia, in his concurring opinion, I think, makes this clear. I mean, and he starts off with going back to the first patent board and says, look, you know, they were exercising the executive power, although it may have been an adjudicated function, and goes on to describe that the federal government has a corpus of administrative law judges numbering more than 1,000, whose principal statutory function is the conduct of adjudication under the APA. They are all executive order officers. Adjudication, in other words, is no more inherently judicial function than the promulgation of rules. Now, I disagree with Justice Scalia in the sense that I don't think all those thousands of ALJs at that point are executive officers, because that lumps in the Social Security administrative judges. Again, I think there's probably about 150 to 250 judges, ALJs out there that do what the SEC's ALJs do, and that's what we're talking about. And it's interesting, the agencies themselves, and this is a quote from the Office of Legal Counsel at Secretary of Education, from the Secretary of Education, and there's also the DOJ Office of Legal Counsel, basically saying ALJs are officers whose duties are generally executive in nature, because the ALJ's decision determine on a case-by-case the policy of an executive branch agency. So that's the key issue that's going to be argued ultimately in these pending cases, is are ALJs basically acting at a level that's really executing the laws. So the government has raised the issue, well, you can't find that they're inferior officers because this is going to be the problem. Well, there are arguments that the government can make here, and it's not clear how a court would rule, and it's ultimately not clear how the Supreme Court would rule. So, what's next? Let's say there was a finding of inferior officer in Lucia, and another case comes up, and separation of powers issue is raised, and the court finds, yes, there is a separation of powers issue. Well, the issue then becomes, well, what do you do in that circumstance? And the circumstance could be, and one of the remedies could be removal of of the tenure protection. And that's what the Supreme Court did in Free Enterprise v. PCOB. They didn't find the whole board basically wipe away with the PCOB. In whole, what they did was just basically strike the tenure level, one level of the tenure protection, and therefore the PCOB continued on. It's interesting in the D.C. Circuit, a case in 2012, which concerned copyright royalty board judges. Those judges had tenure protection and could issue final decisions. The D.C. Circuit did not find that they were inferior officers. The D.C. Circuit found that they were principal officers that should have been appointed by the president. Here, the royalty board judges were appointed by the Librarian of Congress. I believe that's the name of it, but was appointed by the lower official and the principal officer. And the D.C. Circuit struck one tenure protection and allowed for the copyright royalty board judges to continue on. So that's one of the remedies, and I think ultimately what the remedy would be.
Can you just explain when they strike one layer of protection, what does that mean? That the president is one layer closer to the...
One layer closer, and still what it would mean is that person could be, let's say the SEC-ALJ. The SEC-ALJ could be removed directly by the commissioners themselves, and it's not limited to just good cause removal. So it's or bad faith, whatever. I forget the standard of it, but
for cause.
For cause. That's it. Sorry about that. For cause removal. So they would strike that, but the SEC commissioners remained. They can't. The SEC commissioners cannot be removed for cause. So the commissioners can remove the SEC-ALJ for any cause whatsoever. So that's how you get rid of the one level. So that's how the Supreme Court precedence has developed over the years, that you can't have two levels of good cause tenure protection. And that's what the D.C. Circuit did in the Copyright Royalty Board case, and that's what the Supreme Court did in the Free Enterprise case. So, but what does that leave ultimately, right? So let's say you take away the tenure level protection. That strikes at the heart of the APA. Then the APA is ultimately geared to ensure that there's independence, or at least this view of independence of the actual hearing officer. And I find that interesting because the SEC has argued consistently until it ratified and appointed its ALJs, that these ALJs were mere employees of the commission itself. But somehow these mere employees were independent, had their own independence, and could not sway from what the commission policy was, what the commission's thinking was. And that's ultimately what I think is at the heart of these cases, is to say, look, pull the veil of independence, because they're not independents. Let's be clear at the end of the day. These are SEC employees. And the chief judge of the SEC a couple years ago had commented that in one of her cases, the SEC has a procedure where you can file for what's called for motion for summary disposition. It's akin to a motion to dismiss. So, and some respondents take advantage of it, others don't, because it's just a waste of time ultimately, because the commission has just brought this case. You're going to go before that ALJ and say, look, the commission doesn't have enough evidence. And the chief ALJ said, look, how can I go against the commission at the end of the day when they just brought this case? I can't find that they didn't have enough evidence or enough allegations to bring the case itself. And that's at the heart of this, I think, ultimately, is that it pulls the veil away from this nomer of independence. So what are we left with at that point? If we go down, what are we left with? There are other arguments going to the heart of this administrative forum and this administrative process. And when I say the administrative process, I'm talking about adjudicating allegations of violations of law. Justice Scalia in the Gabelli case versus the SEC basically said, look, you're labeling this person as a wrongdoer, that they violated Section 10B of the SEC's, the securities laws. That's an anti-fraud provision. You're forever labeled as a wrongdoer. This isn't some sort of technical case that you have violated some technical violation, some SEC esoteric rule. But
and
this
they can impose fines commensurate with that, right?
Completely. So that's where I think the real struggle is in these cases. So the core issues are two: due process, and I take the due process as two issues. One is, look, there is the due process. Did you get due process within that form, and ultimately, does the form itself have due process? Lack of impartiality, federal rules of civil procedures aren't there, federal rules of evidence, right to a jury trial. And then ultimately, equal protection. The SEC can bring cases both in its own administrative forum and in the federal court, but it doesn't tell you when or why. Ultimately, Congress never gave them any guidelines as to when you can bring these cases. And that's where the unfairness comes in. The equal protection standard is hard, is a difficult standard to make this argument in, because it's never been brought in this kind of context. And just think about this. Why can the Commission bring a case and pick whatever case it wants and bring it in an administrative forum, but for other defendants, bringing in a federal court where you get a right to a jury, you get the federal rules of evidence, you get a Article III judge. But in the administrative forum, you get none of that. And you get less discovery. So these are the core issues that I think are going to be left for courts to remain to grapple with. And it should be interesting, given the composition of the Supreme Court now, to see whether they take ultimately these issues head on.
Okay, great. Thank you very much, George. And now Allison is going to speak with us specifically about the Lucia decision and the administrative process in the context of CFPB proceedings.
So the Consumer Financial Protection Act, which is, you all probably know, is Title 10 of the Dodd-Frank Act, the enabling statute of the CFPB, expressly has a provision in it that enables the CFPB's Office of Enforcement to bring actions either in the administrative forum of the agency or in district court. And there's no distinction. They can bring the same case in either forum. And similar to what George just described with respect to the SEC. And it's a curious issue, because I think it does actually bring up all kinds of issues that address these questions of due process and equal protection. And as I'm listening and reading about Lucia, what really strikes at the heart of the whole issue, I think, is not this question about is an entity or is an individual an inferior officer, but really what are the types of adjudicative decisions that these individuals are charged with making, and how far-reaching do those consequences go? If you have an administrative law judge who's essentially engaging in the same kind of fact-finding and rendering of conclusions of law as an Article III judge as to the same causes of action, obtaining the same remedies, which is exactly what the Consumer Financial Protection Act provides for. How in that way is that fair? And just a little background. To date, the CFPB has brought a number of cases in its adjudicative proceeding, its administrative forum. To date, only two have actually gone to trial. One was PHH, which just went up to the D.C. Circuit panel and then en banc. And another is currently being held in abeyance. It's a matter, actually, that my firm is handling, and it's being held in abeyance pending disposition of the Lucia case. So to date, the Bureau has only tried two actual cases in its administrative forum. It has a number of cases that have been brought but have not actually gone to trial. The CFPB at the time of creation it was contemplated that the Office of Enforcement would promulgate rules of adjudication, which it did. Actually, when I was working at the agency, the rules of adjudication were promulgated, and there was a lot of conversation about what those rules should look like. And I can tell you that the Bureau looked to the Federal Trade Commission, they looked to the Securities and Exchange Commission, primarily those two agencies, to get a sense of what the rules should be. there's a few issues with those rules, which I think are kind of critical because they really go to some of the issues about this question of fairness, or call it due process, or even equal protection, which we can talk about in a few minutes. The rules contemplate a very truncated discovery process, and by that I mean if you kind of think about federal district court litigation where you've got a complaint, an answer, or motion to dismiss, you've got fact discovery, you've got expert discovery, you've got a summary judgment, maybe then you have pretrial briefing, and then you have a trial. In the administrative forum of the CFPB, there is virtually no fact discovery. You have instead what's called kind of like the open file rule, which is essentially the Bureau has to turn over, as part of its affirmative discovery obligation, its entire investigative file minus that which it would call deliberative process privilege, that which is protected from the process privilege. And so that's essentially the discovery file that you get. You get a little fact discovery, but very little is contemplated under the rules. If you want to bring if you want to seek additional discovery through a subpoena, you have to actually move the administrative law judge to issue that subpoena. There is expert discovery that's contemplated, kind of traditional expert discovery where there are reports and depositions that go back and forth, but that's really the extent of it. And then you move really quickly into summary judgment, and then after that, trial. And it's a very quick, expedited process, and that's, depending on your perspective, may be good or bad. If you're a defendant in that proceeding, it may be bad because you really get a very truncated fact discovery opportunity. I guess if you're the Bureau, you may think it's good to the extent that you feel like you have a good case and you don't want to pressure test it too much through regular district court proceedings. So some of what is interesting here is why the Bureau has only brought 2 cases to date. And I should back up and tell you that the Bureau really stopped using this forum once Bandemir in the 10th Circuit came down. And Bandemir in the 10th Circuit, which was actually an SEC case, essentially said that decision was vacated because the appointment of the administrative law judge in that case was found to be unconstitutional. That's the circuit split that was discussed earlier in this presentation. So subsequent to that decision, the CFPB basically stopped using its administrative forum until this matter in Lucia is disposed of. But even before that issue, the Bureau had actually brought very few cases in the forum, and I suspect that there's a couple of reasons for that. Number one, as a matter of familiarity, the lawyers in the Office of Enforcement are really district court litigators. That's kind of where they all cut their teeth. I can tell you that from my own experience there. And so there was a little bit of uncertainty about what that forum meant, the administrative forum, how it works. The rules aren't really rules that a lot of people know a lot about. And actually, when you litigate in that forum with those rules, you see there's a lot of gaps in the rules because they just don't have the kind of common law doctrine that backs up the federal rules of civil procedure or evidence, for example. Number two, one thing about the administrative forum, which maybe is beneficial if you're a defendant, it generally engenders less press. One of the great things that the CFPB has done with its enforcement office, great or bad, depending on your perspective, is it's used press very effectively to further its enforcement goals. And when it brings a matter in the administrative forum, that press is less apparent because district court litigation is more readily accessible. So that's one issue that I think has been curious. But I think really what you're seeing here is a fundamental question about whether it is inherently fair to have a forum where the very same issues can be decided in can be decided in this forum with a truncated discovery process or in the district court forum. And I want to talk a bit about some of the critiques of the administrative forum to date that have arisen. As I said, there have only been 2 cases that have been tried, only one that's really been disposed of and gone all the way up to the D.C. Circuit. So the way the forum works is that there's an administrative law decision, which is actually a recommendation. That recommendation then gets forwarded to the director of the agency, and after 40 days, if nobody raises an appeal, neither party, neither the Bureau nor the defendant respondent raises an appeal, the director of the CFPB can either adopt the recommended decision of the administrative law judge, he or she can amend that decision, or they can seek additional briefing on a particular set of questions. And so, for example, in the PHH decision, which of course was subsequently appealed to the D.C. Circuit, what happened in that case was that the CFPB then director, Rich Cordray, was criticized because he essentially took the administrative law judge's findings and by I think an exponent of 11. I think he multiplied the findings by 11 and came up with a penalty, a civil money penalty, that was quite a bit larger, exponentially larger than that which had been recommended. In addition, in that particular case, the director announced that in his view, through reading the Dodd-Frank Act, the Consumer Financial Protection Act particularly, there was no statute of limitations applied when the Bureau was bringing unfair, deceptive, or abusive acts or practices cases, UDAP cases, in its administrative forum, because the statute of limitations prescription in the Dodd-Frank Act only enunciated or appeared to enunciate district court proceedings. Now, obviously, that was subsequently found to be not correct by the D.C. Circuit, and curiously, the D.C. Circuit's panel found that to be the wrong reading of Dodd-Frank, and the Bureau did not appeal that up for en banc review. So that finding, that holding by Director Cordray, was overturned. And then another critique of the administrative forum has been, and it's similar to what has arisen in the SEC context, that the Bureau is essentially both the prosecutor and the judge. And this is, in general, I think, kind of goes to the heart of some of the issues that arise in this situation. One of the issues that is very curious when you litigate in the administrative forum of the CFPB is that if you were to litigate the same case in the district court, the name of the party, if you were the defendant in that case, the name of the party on the other side would be the Consumer Financial Protection Bureau or the CFPB or the Bureau. But in the administrative forum, the name of the other party is Enforcement Counsel. That's not a picayune distinction. That's a very important distinction because Enforcement Counsel is derived to be a particular component of the agency that is rendered separate from the director who's charged with making the ultimate decision in the administrative forum. It's a curious issue, and it kind of goes to the heart of some of the concerns here about independence. So, for example, the way it works at the Bureau has historically, there's a wall, if you will, that goes up between the director's office and Enforcement Counsel when there's an administrative forum case that's being litigated. What's interesting about that, though, is at the outset of an enforcement action, the director, the very same director, has to give approval for the bringing of that action. So the director approves the bringing of that action. That action then gets brought in the administrative forum, and then there's a wall that goes up, and that wall comes down only at the end of that process. But as you might imagine, that circle is a loop that maybe is a little too close for comfort if you happen to be a respondent or defendant in that proceeding. Now, recently, with Mick Mulvaney coming in as acting director, he's put forward a number of proposals, including one that seeks what's called a request for information about the nature of the administrative law process at the CFPB. And it's interesting because the RFI, the request for information about the administrative adjudication process, has a lot of questions associated with it, and they're kind of questions that they're asking stakeholders to answer. And the very first question is whether, as a matter of policy, the Bureau should pursue contested matters only in federal court rather than through the administrative adjudication process. And that question actually gets to the heart of this entire presentation, right? Because really what's at issue here isn't the question of whether an ALJ is an inferior officer subject to removal power. What's at issue here, and this is one of the ways that Lucia's counsel tried to kind of hem in, come up with a limiting principle during oral argument, is what kinds of proceedings should be susceptible to adjudicative review. So you're talking about a Social Security Administration proceeding, which is quite a bit different from one before the CFPB or the Securities and Exchange Commission. You know, the CFPB can issue, can have its ALJ recommend hundreds of millions of dollars in civil money penalties. You know, you're not talking about a scenario where it's a licensing issue or even a question about whether you're entitled to a right or a benefit, which is, of course, no easy task in and of itself. You're talking about a scenario where an administrative law judge can recommend the imposition of penalties and fines that could really render somebody bankrupt. And to have a scenario where that happens either in that forum or in the district court where you not only have the benefit of potentially a trial by jury, but you also have the safeguards of the Federal Rules of Civil Procedure, and the most important safeguard of all, of course, is the Federal Rules of Evidence. You don't have any of those safeguards here. So you could be a defendant in one proceeding and get those safeguards, and in another not get those safeguards. And that really kind of goes to the heart of this whole issue. Some of the other questions that the request for information seek are the way that the administrative adjudication proceeding moves expeditiously. Should it be the case that you have to file an answer to a complaint in 14 days? In district court, you usually get 21 days. That's often extended. Should it be the case that a summary judgment motion has to be decided in 30 days? In district court, that timeline is usually much longer and gives the judge and his or her clerks an opportunity to really dig in and learn the case and learn the facts, especially if it's a question of first impression, which I'll talk about in a moment. And then there's some other questions that the request for information has also sought. Should there be a limit on the number of expert witnesses? Should it be the case that the length of limitation for motions are favored or disfavored? So there's fairly strict page limits in some of these proceedings before the CFPB. Should that be something that's allowed to happen? And then, of course, one of the key questions that's being asked is whether or not the administrative law proceedings should adopt the Federal Rules of Evidence. And even if they don't adopt the entire Federal Rules of Evidence, should they adopt at least the hearsay rules? The rules that basically say out-of-court statements entered for the truth of the matter are generally not admissible, subject to certain exceptions. And, of course, that's kind of a due process protection that's codified in the Rules of Evidence, right? You pressure test out-of-court statements because that's how we ensure that witnesses and statements are credible. And that's an insurance that I think, those of us who are district court litigators really embrace. And so when you're in this administrative forum and you have witnesses taking the stand who are just making flagrant hearsay statements, and there's no method or mechanism baked in to prevent that, that really does call into question some of these issues. But one of the other curious things about the CFPB's forum is that a lot of these questions are questions of first impression, at least right now. The Bureau has its own unfair, deceptive, or abusive acts or practices law, and that law hasn't really been built out yet. And so for the next, call it 5-10 years, you're going to see a lot of that law getting built out. And do you really want some novel questions of first impression decided in a forum where there's no rules of evidence, where there's no rules of civil procedure, where the administrative law judge making that decision isn't necessarily hemmed in by the same Article III considerations that a district court judge is? And so those are some of the issues that I think are really critical issues here. The Lucia case obviously will affect the CFPB. It will affect the SEC, as John said earlier, likely affect the Federal Trade Commission to some extent, and some other agencies that have so-called adversarial proceedings that are in front of administrative law judges. But it also will, I think, materially affect the way agencies think about the cases that they bring, how hard they have to prove those cases, how much pressure testing goes on. If you're before an administrative law judge, maybe you don't have to worry so much about the credibility of your witnesses. Maybe you don't have to worry so much about the kind of very rigorous rules of evidence that you get held to when you go before a judge and you prove your case, especially as a federal prosecutor. But I think it's fair to say that this will ultimately affect the way cases get brought in the near future. Yeah, Peter, please.
And just to follow on something that George had said, that using the appointments clause issue as a hook into these more fundamental issues that Allison was just talking about. What George had mentioned with the SEC ALJs, talking about, you see similar things occurring on the CFPB side. So, for example, a complaint filed by Intercept sort of preemptively as enforcement action by the CFPB was pending, they alleged there that enforcement counsel had, during the investigation and negotiation process, made claims and representations regarding the administrative forum as being a home court where they could file and sort of stick that party in for 300 days, and there'd be no way out. And really, as George was saying, a way to incentivize or to push settlements by sort of threatening this home court advantage that you're not going to be able to escape and get out to the federal court system until you have a judgment against you and have litigated for almost a year, or a little bit over a year, depending on how the days work out. Ultimately, that case was filed in federal court and dismissed because they were inadequate claims in the complaint. So, just raises the question. Obviously, the Intercept had withdrawn its complaint, but it does raise the question whether or not the administrative forum becomes, especially when you can seek these identical remedies, just a landing spot for your cases that are underbaked, not fully developed, but for whatever reason the agency is pushing forward, whether or not, whether it be they're pushing up against a statute of limitations issue that they want to avoid, whether they just, for policy reasons, that feel like the case needs to be brought now, although Enforcement Council might not be truly ready to bring it, and whether or not that's a safe space for them to bring kind of, cases that maybe won't fly in the federal court system as easily. So certainly all those fundamental protections that we've talked about do come into play.
Could you, and I defer to anyone at the table, explain, I think it's part of the narrative for this home court advantage theory. How do you, what role do you see the CID process or the investigative process and the evidence gathering that the agencies have at their disposal? They have, so many tools that they are able to use prior to any, instituting any enforcement action against a party. That would seem to also contribute to these discussions about equal protection and due process. Do any of you have any thoughts on that?
Yeah, it's a great question, Meredith. So in the administrative forum, for example, in the CFPB context, the way you respond to a civil investigative demand may be the only opportunity you have to affirmatively shape the facts of the case, which takes that CID process and really escalates it and makes it much more than just not that a mere subpoena is anything from a law enforcement agency, but very serious. But it really does change the dynamic. If you're in federal district court, you have the CID to which you've responded, but you also have an opportunity to seek additional discovery, which we've seen. We've seen that happen a number of times in the CFPB context with litigation, where the CFPB has been put through its paces for good reason, and in some cases has done very well, and in other cases, candidly, you've had judges say, guess what, you don't have a case. You either don't have a case, or your discovery doesn't add up, or the restitution that you're seeking isn't there. In the administrative forum, you don't have that same pressure testing. And so the CID process becomes so much more critical because it's the only mechanism into which there is any kind of facts being poured, if you will, and mixed up. And so I always encourage people when they receive a CID to take it extremely seriously, because it could be the last time that you have an opportunity to shape the way the story gets told, especially if you end up in an administrative forum.
Mm-hmm. John, I was hoping you could explain a little bit more, and George too. I'm very intrigued by this removal conundrum, and I'm curious to hear your views on how it might be extrapolated out to other contexts, outside the ALJ range, the ALJ realm.
Well, I think that's what some of the justices were concerned with at the oral argument for Lucia. It was interesting because I hadn't heard it at the D.C. Circuit or at any trial level on when these arguments have been raised. Can you extrapolate basically inferior officer to other what are deemed employee positions? Like, you could take someone in the enforcement division of the SEC, or someone within, I don't know, pick another division, a more regulatory side of the house, whether that person is acting at that sort of level. And, what do you do at that point? But the removal issue, I think, ultimately is one that's going to be, it's going to press upon sort of, okay, what are their tenure protections at the end of the day, and what is the cure ultimately for that position? And I think the cure can be pretty easy at the end of the day. It's just stripping the tenure protection, but for some employees like the ALJ, it raises the independence issue. And I think at the PCAOB level, it was an easy fix for the Supreme Court. But I think Justice Breyer, with his hindsight, said, look, this raises questions beyond this case. And I thought, it's interesting. The posture of the Lucia case is that the three-judge panel found that there wasn't an inferior officer, but when it went to the en banc review, several of the judges on the DC circuit were really concerned about the removal issue, and the court split 4-4, and that left basically Lucia standing still on the three-judge panel decision. John, you got?
No, I think you've hit it all. The justices are worried about this because the scope of the decision is essentially unknown. They never dreamed, I don't think, that PCAOB would come back and throw a major monkey wrench in the gears of the ALJ process, or if anyone did, it was Justice Breyer, but the others didn't see that coming. And I think that they sort of have, they're spooked, if you will, now, because they just don't understand the complete ramifications of classifying as somebody as an inferior officer in an appointments context and how that might be used in the removal context. So I think that's why when the administration, through the Solicitor General, invited the Supreme Court to take up the removal provision, they showed absolutely no interest in it. They don't want to take on too much too quickly. They need the breathing period, and they need the development of the issue in the lower courts before they'd be at all comfortable and considering the breadth of the ramifications of an inferior officer holding here.
Well, thank you all so much for joining us today. It's been a really interesting discussion for me, and I think for everyone at the table, and I hope for you too. And thanks for listening to our podcast from Venable LLP.